Welcome to this edition of Real World Employment Law, where we discuss real-world issues affecting businesses and executives. I'm Declan Leonard. I'm the managing partner here at Leonard, and I also head up our firm's employment law practice.
And I'm Elizabeth Payne-Maddalena. I'm one of our senior associates who works on employment law with Declan.
And Liz, as we're doing this podcast, doing it obviously socially distanced, and I noticed you got the terrible towel up there. I bet you that's had more tears on it these last few weeks than normal.
Yes, you had to bring that up. Yes, it's hasn't been a great end of the season for Steelers fans. I'm confident, though, that next season will hopefully bring us better things.
Yeah. But You've got Dwayne Haskins. You just signed Dwayne Haskins, so Big Ben is fine, man. Everything is fine. He'll be able to eat all the fast food he wants. He doesn't have to stay healthy with Washington's Haskins over there in Pittsburgh.
We'll definitely see. I will say I'll give the Washington football team its credit in having a season where it started breaking some of those curses. And Alex Smith had a great season. It was a great comeback story. I'm sorry you guys didn't go any further, but it was still a good way to end it.
That sounds very patronizing from a Pittsburgh fan. I love it. Hey, anyways, so let's jump into this. Liz, we got a good topic today. It's actually a universal topic for companies. Employee handbooks. We're right after the new year here. We're taping this, what is it, the third week of January. We've got the Biden administration in. And so this is an opportune time, whether or not it was a change of administrations or not. It's an opportune time for companies to look at these handbooks and see, you know what, let's dust it off and see what needs to go in there. What are our clients looking at in terms of getting their handbooks reviewed?
Right. So, as you said, it's always a good thing to check out and go through your handbook at the beginning of the year, especially when you have a new administration, but also because laws are constantly changing. And especially in Virginia, there have been some big changes to Virginia law over the year. But even when you don't have these big legal changes, you certainly want to make sure that your handbooks are just general guidelines and really just helping lay out to employees how the business is going to be run without going into too specific of details as to exactly how every single thing will go, because that's where employers tend to run into a lot of trouble.
Yeah, I find that handbooks do create some confusion for companies, and specifically the purpose of them. Sometimes they think that this is, this is an operations manual, that it's going to have everything under the sun in there, but that's not really what an employee handbook is it?
No. Employment handbooks are really just about, again, it's keeping things general, but you want to make sure that they are flexible, and it shouldn't cover every specific situation under the sun. And that's why you want to make sure these are flexible policies in there. Most importantly, I would say these are not contracts either. Just because you have an employment handbook with an employee doesn't mean that you have a contract when it comes to things like confidentiality agreements either. Those are separate. So you want to make sure that you keep that in mind when you're going through your handbook for the first time, the fifth time, or the 500th.
Yeah, we'll be talking about some of the changes, Liz. You already mentioned, here in Virginia, we've got some new laws on the books. So companies really do have to make sure that their handbooks reflect that. And I think it's worth noting that this is not a one-time thing, that companies really have to look at these handbooks as living documents. A great example would be, as we were coming into the podcast studio today, about 4 hours ago, the new Biden administration has directed OSHA to come up with new COVID safety rules to guide workplaces, and that very well may have an impact on what people have in these handbooks, or whether or not they actually do a standalone policy for that. So it just goes to show that even doing it once, you probably should look at this probably twice a year. It doesn't mean you have to hire a lawyer and rewrite the thing. It's really just a matter of updating as necessary. Sometimes that could be in an amended handbook, or I should say an updated handbook, or sometimes that could also be in sort of standalone sheets that we sometimes provide our clients to supplement the handbook.
Right, and those standalone policies can be especially helpful in the time of COVID too, because a lot of employers are adjusting as they go to these new regulations, new laws, and just the new new world we find ourselves in that's constantly evolving. So having standalone policies can be very helpful, especially so that way you don't have to then change your handbook every, few months or, few weeks, even as things change or evolve in different areas, different states, or with different developments when it comes to the COVID issue.
So let's jump in. Let's talk about a few. We're not going to hit everything today. Obviously, we could spend a couple of hours going through every point that you'd want to have in a handbook, every point that perhaps you wouldn't want to put in a handbook too. But let's talk about some of the more popular ones right now that we think companies and executives should have their minds sort of focused on as they go through this handbook review with their counsel. Why don't you jump in and hit some of these?
Sure. So the first one, and we've mentioned a lot that Virginia's had some pretty expansive changes over the last year to its employment law through the Virginia Values Act, and that actually went into effect mostly last July. But there are some key parts where this affects employers and employment handbooks for employers who are in Virginia. First is when it comes to pregnancy, childbirth and post-childbirth accommodation and lactation breaks. Those are things that are now required in Virginia if you're an employer with 5 or more employees. And where this really comes into play is the law requires not only that you can't discriminate against someone who requires pregnancy, childbirth, post-childbirth lactation accommodations, but also that the employers need to give those as long as they're reasonable. And they also need to give notice of these new laws and the availability of these accommodations within certain time periods and including in employment handbooks. So that's where it becomes very important.
So the handbook actually comes in handy in actually complying with the law in this particular circumstance. And as we see, we advise companies all of the time on employment matters, but we also handle employment litigation. And as we see, an employee who is potentially looking to take action against a company or a former employee, one of the first things that the attorney for that employee is going to do is they're going to probably scour through the handbook, see if there's anything in there to be used. And as you just pointed out, these are notices that are required to be in there, and it's hard to explain when you don't have them in there when you're reactionary in the midst of litigation. So why don't you hit a couple more of these?
Right. So another one, when it comes to both the Virginia Values Act, but also a recent Supreme Court decision, Bostick versus Clayton County, meaning that it's going to affect everyone, or every employer in the United States, is employers are not allowed to discriminate on the basis of gender identity or sexual orientation. And this is just something where when you're going through your handbook, you want to make sure that your non-discrimination policies, which every employer should have in their handbook, includes those 2 categories. And the other thing where you might want to do is look in some relevant sections of your handbook to make sure that any other provisions that could be discriminatory or be viewed as discriminatory on this basis, gender identity especially, are updated. And one thing I always like to recommend too is just trying to see if you can use gender neutral terms when you have the ability to in your handbook.
One of the things that we've recommended our clients, because let's face it, keeping track of the list of protected classes in the employment context is not always easy, because you've got the federal, which, as we know, under the U.S. Supreme Court ruling, has now changed and broadened. We know that various states have their own. I mean, every once in a while, if you look at D.C.'s, which is obviously our neighboring jurisdiction here, they've got so many protected classes, things like matriculation, personal appearance. So what I always recommend we do is to say, as well as any other applicable protected classes under any applicable state or local law, federal, state, or local law, because you also have local human rights ordinances. Locally here, you've got Arlington, Fairfax, Alexandria, and sometimes they even have broader categories. So you kind of want to have a catch-all too, just in case you miss any, because it's not purposeful. It's usually just going to be inadvertent, and you don't want that to be used against you. That's a good one. What about social media policies? That is something that we have seen in handbooks, and I'm curious, what do you think a company should be looking at with regard to having social media policies in their handbook covered? And first, if you could, just kind of talk about what we're even talking about social media policies when we put them in a handbook.
Right. So social media policies and handbooks, it is definitely something that is very popular nowadays. We are in a world where everyone and their grandmother has a social media account of some sort, it seems like. So employers are rightfully concerned about what could potentially be said on behalf of the organization on a social media account. But employers also want to tread that line carefully when it comes to, you know, the politically charged atmosphere that we're in nowadays, or also stepping over any lines when it comes to, restricting employees' abilities to talk about salary and other protected issues under the Fair Labor Standards Act. So that's something that is where social media policies can be particularly sensitive, and employers want to pay close attention to that and how the law is developing in that aspect.
Yeah, we saw, and this is one that sort of plays what I would call maybe the political yo-yo, goes back and forth every time there's a new administration from a different party. So during the 8 years under the Obama administration, the National Labor Relations Board, NLRB, they're the ones that actually tend to police these social media policies. It's convoluted how that is the case, but that's all you have to know. Is NLRB tends to police these. Sometimes the EEOC does too, the Equal Employment Opportunity Commission. But those are political organizations in large part because each administration comes in and staffs those positions, the powerful positions there. They staff them with their people. And so, for instance, during the Obama administration, they were clamping down on social media policies in handbooks. There were a lot of companies that got dinged for this. CVS is one of them. There were a couple of others. And then, perhaps not surprisingly, during the Trump administration, this oversight function was very, very much relaxed. Now that Biden is in office, I think we can probably expect that the pendulum will swing back to where they were under the Obama administration or somewhere similar. So that's a great example of how you have to keep looking at these handbooks and not just look at them as kind of like static documents that you never look at again.
Exactly, yeah. And that's something where, again, that twice a year review, if you could just get into the habit of doing that or set a calendar event to do that, just twice a year comes in really handy, because then you can make sure that you are staying up to date without having to remind yourself, oh gosh, it's already November and I need to update this. And oh, there's been these decisions that are out and this is, now could become an issue. If you just get into the habit of doing it twice a year, you won't have to worry about that nearly as much, and it'll really be helpful in the end with staying on top of all of these changes as they develop.
Liz, one of the things that we've had to contend with, and it's pretty common for companies nowadays, is they operate or they have employees in multiple jurisdictions, multiple states, and each one. So I'll take an example: sick leave policies. You've got DC has a very specific sick leave policy. Maryland actually has its own sick leave policy where you have to give a certain allocation of sick leave to employees throughout a year. And so one of the difficulties is this handbook is kind of a one size fits all. What we have advised our clients to do is to do different attachments or addendum to cover individual state laws, because what also happens is a Virginia employee is going to be looking at this and saying, why is my Maryland counterpart getting all this time off? I mean, they don't really get more time off. It's really just how it's worded in the leave policies under the handbook. So that's another example.
Yes, that is a great example, and especially in the DC area, I feel like, where it is much more common for employers to have offices in 3 different jurisdictions: DC, Virginia, and Maryland, in which case you would have to have different addendums for DC and Maryland if you were a Virginia employer, and vice versa. So that is a great point.
Yeah.
This also is helpful when it comes to watching some of the state laws and the way things are developing. Another example that is an area for employers to maybe just watch and keep an eye on is interestingly enough in the use of marijuana and the expansion of marijuana legalization. Um, you know, what we're already seeing in some states is that there are employment protections coming into place for employees who use mostly medical marijuana, and that really impacts, hiring, drug testing, and also, drug and alcohol use policies. As there's now this, you want to make sure that you're complying with the state laws in those states, but you also are going to have a patchwork as different states have different laws on marijuana, medical marijuana, and then there's also the federal prohibition on this. It's still illegal under federal law, although that may change too. So it's just something important for employers to keep an eye on and consider. And it's another example of how, for multi-jurisdictional employers, it's always better to have these separate individual addendums to just address these differences.
Yes, and God forbid you've got employees in California, because you'll have a whole separate manual just to cover all of the various regulations there. But anyways, I guess I digress on that one. The last one we should hit on is family leave policies, specifically sort of parental leave policies, leave that is granted for the birth or adoption of a child. Talk to us a little bit. You and I have worked on a number of these handbooks, and this is an area that I believe continues to confuse and perhaps trip up companies in terms of how they do it. They're all very well-meaning in terms of the leave that they're looking to give, but it's the way they express it sometimes in these policies that we've got to work through.
Right, and this, now I think it's even more heightened under the Bostic Supreme Court decision that we were talking about earlier. Because one thing that we found with the current guidance and case law is that a lot of these policies are tied to maternity leave. That's what they call it, and they are tied to gender in that way and not childbirth. And the thing is that, the current law shows that you want to make sure that these kinds of things are tied to childbirth, and any leave that's beyond for the purposes of recovering from the medical effects of childbirth is more general parental leave. That is something where I think that's where a lot of employers get tripped up. And again, as you said, it's very well meaning. It's just, this is the current view on the law.
Yeah, so in other words, you can differentiate, and obviously there's difference obviously between childbearing and child rearing. So you can differentiate with regard to the law, your company policy when it comes to this. So if you wanted to give a mother who gives birth to a child, you can give them a medical leave. Let's just say you're giving them 6 weeks or whatever. But if you then give additional leave that is really just for child rearing to bond with the child, everybody has to get the same. The mother, the father, and then when it comes to adoptive parents, both of them, since that's not a situation where either one of them is giving birth, then you have to give the exact same amount there too, and it trips up people. And again, I think it's very much well-meaning, but it just trips up people, and you don't want to fall in any of these traps that could get you in trouble when all you're really trying to do is make sure that people get the appropriate leave and give them as much leave as you can, during these happy but sometimes trying times. Let's face it.
Exactly, and I think that's where that's part of the reason why we do these podcasts, and we also release alerts on our email to our email lists to clients, and to make sure that they're aware of these changes. So that way, if someone knows that, oh, we have a policy for parental leave that's really supposed to be for childbirth, but we're still calling it maternity leave, you can go ahead and make that change very quickly, and you don't have to wait and find out and make that change after it becomes a problem, which is always the worst time to do it, as you and I both know.
Yeah, no, absolutely. I usually refer to it as these handbook reviews are fairly light lifting. I mean, they're usually pretty voluminous, so you got to go through them, but they're pretty light lifting. And we're not looking to I always tell clients, give me your handbook. I'm not going to create one necessarily whole cloth. There have probably been times when we've been asked to do that, but most of the time, I want to see it in their writing. I want to see them capture the culture of the company, and then we can just look at it from a legal standpoint and change anything that's needed just to get into compliance.
Exactly. And again, also make sure that the policies that they have are also broad enough and flexible enough so that employers are able to respond to any situation that they encounter without having to follow a procedure that may not be necessary or really cumbersome actually in some situations. And they're able to be flexible because in the end, that's what employers need, is that flexibility too.
Absolutely, Liz. Great discussion on an important topic for companies to make sure that they have these updated on a regular basis. I want to thank everybody for joining us for this edition of Real World Employment Law, and stay tuned for the next one.